Good evening, this is Rahul Reddy. We're live here every Tuesday. Along with me is my business partner, Rebecca Chen. Rebecca Chen has been with our office from 2010 to right now. She has been in immigration field since she was in high school. I don't know how long you've been, first time you worked in immigration law field?
Yeah, I guess over 20 years ago.
Oh, 20 years ago, okay, that's good. Today we're going to discuss about duplicate H-1B registrations in lottery are leading to the permanent bar to not ever come into United States. These are the people who have filed for duplicate H-1Bs. That means that they have filed with multiple different companies. We're going to discuss about that. We're going to discuss how does the USCIS maintain their files when they call you for the interview, when they adjudicate for your application. We're going to discuss about also going to discuss about if you file an adjustment of status in EB3 and now you change the job. When you file the 485, you filed under downgrading from EB2 to EB3. Now you change the job. Is there any way that you can claim back the EB2? We're going to discuss about it. There are some positive ways where you can definitely get the EB2 done. There are some dubious ways we're not sure whether you can get it done or not. But we're going to discuss both the things and we will put things in your barcode. Also, will the dates move to December 2015 soon? That's definitely a topic that is a hot topic that's discussed, where we're going to discuss about what are the predictions that we see? The dates for EB2 are moving very fast. What is expected in it? We're going to discuss about that. Rebecca, we have always advised people not to file the duplicate H-1B applications, though. So what's going on that? I mean, what is the, why is that where is that they're hitting the misrepresentation?
Yeah, so there have been some incidents at the consulates recently that we have heard of where people applying for an H-1B visa for the first time at the consulate and who got their H-1B selected in the lottery in the previous couple of years are sometimes getting their visa denied. The only thing that they are told is that you are ineligible for a visa based on fraud or misrepresentation, but they are not given any other information by the consulate about the facts, about what led the consulate to decide that they had committed any misrepresentation to the government. On further investigation, it seems like we have learned that sort of the common thread of these recent visa denials for misrepresentation were situations where the visa applicants all had multiple H-1B registrations in the electronic lottery. I think not this year, but in the previous 2 years that the lottery has been electronic. In March, they've had multiple companies submit them in the registration for the lottery, sometimes 7 or 8 different companies. And that seems to be the common thread right now, and they're getting hit with a misrepresentation claim at the consulate. So we have definitely warned in the past about kind of the risks and some of the dangers with filing multiple H-1B registrations in the lottery, especially with companies where you don't actually have a job offer, where you're not actively working for the company. And it seems like, of course, with the electronic registration system now, it is very easy for the government to kind of data mine these situations and see, based on your passport number, your date of birth, how many different companies filed your H-1B registration in the lottery. So I don't know, with these types of misrepresentation claims at the consulate, it's very difficult to overcome. I think that's why we mentioned it could lead to even a permanent bar against re-entry to the United States. There isn't a clear way to overcome a misrepresentation bar for a non-immigrant visa at the consulate. At most, what you can do is apply to the consulate, try to explain the situation, try to explain if make an argument for why you didn't personally really misrepresent anything, and see if the consulate is open to reconsidering. But there's no real formal process for that. There's no set time frame that the consulate is required to return a decision. You just kind of have to try for that waiver and see what the consulate says. So it is a very difficult situation.
I think so. They can. The first thing is, if anybody has used my name, Rebecca, to file the H-1B, I can go ahead and complain to the USCIS. Look, this particular ABC company has used my name. So in that way, that when they go to the consulate, look, I did not authorize this company to use my name, though. It so happens some of these people are forced to give their name out there. Some of the time, where what they have given to one company, they used it, other companies have used it. So if you're one of those victims, though, definitely complain. Keep a copy of the complaint so that at a later date, though, when you have an issue with regards to the dates, though, you can come up when you have issue with the misrepresentation, you can show the evidence that, look, I've already made a complaint against this particular company, so in that way you can avoid it. But if you are one of the guy who have filed for the duplicate with multiple different companies, I think so the best way is to contact a lawyer. The other way maybe is probably avoid traveling at all to India and getting the stamping, Emily, Rebecca. That may be one of the other things that you can do. Rebecca, let's discuss about how does the USCIS maintain the file, though? How do they maintain the file?
Yeah, USCIS is not really in the 21st century quite yet. Most of their file maintenance is physical files, just paper files, which is why for employment-based petitions, there isn't that much actually e-filing that we do. All the non-immigrant visa petitions, I140 petitions, I485 applications are all filed by paper, and USCIS keeps them in paper files. And in order to review the case, the officer has to have the physical file in front of them. There have been some cases where in the past we've gone to green card interviews that have been scheduled, and we appear at the interview with the client, and the officer says that actually we can't hold this interview today because we requested the file from a different office and it didn't arrive. So they really still rely on these kind of paper physical files, especially now with the adjustment of status applications this year, with all the files being transferred from the Texas Service Center to the Nebraska Service Center. That's why, to the National Benefits Center, which is a good thing. The National Benefits Center is faster. It has a faster turnaround in processing the I-485s, but they are actually, shipping all these files from Texas and Nebraska to the National Benefits Center. The National Benefits Center then sometimes ships files to local field offices for local adjudication, sometimes for the purpose of an in-person interview, sometimes for the purpose of just spreading out the workload. So it is, that is partly why the process
Rebecca,
seems
you've been
so
working
slow.
in different law firms, and I'm one of, we are one of the law firms before that. Even within our own law firm, things have changed a lot in the past 12 years you've been in our office, and previously you were with the other law firms where, practically I was in the typewriter. Why is that this USCIS has not modified very much, though?
Who knows? They have not really updated to kind of an electronic system that's very efficient. One area where it does seem like where there is some progress is with the I485J supplements. So we do know from a recent stakeholder engagement call with USCIS that for the I485J supplements that are being used to transfer the underlying basis of the I485, basically to interfile from EB3 to EB2, since February of this year, where we started sending the J supplements to the Western Form Center, USCIS did say that they are electronically scanning the J supplements there in California at the Western Form Center and electronically updating the I-485 file, which is most likely at the National Benefits Center. So that is one good thing. They're not having to physically mail a bunch of J supplements from California to the National Benefits Center. Other than that, it does seem like a lot of the file maintenance is still physical, which is why, unfortunately, there are still delays. Things take a long time to update. Sometimes there are errors in updating. Sometimes families who file together get their adjudications at different times for some reason, and sometimes it's just a matter of two of the family members' files went to one officer, another file went to another officer, and that's why for some reason there are these kind of inconsistent or delayed adjudications.
Yeah, what we at this point of time recommend although is that especially if you have not filed the medicals, don't wait for the RFE because they're very fast approving. If it gets to the officer's hand, they're approving it very fast. So we strongly recommend to do interfiling. We want you to go to the Reddy Neumann PC, and we want you to go and interfile the medicals. That's the best thing that you can do. And do one thing when you do the medicals though. Please make sure that you get an extra copy for medicals, so that you can actually file if they issue an RFE though, you can actually have the second one to be filing. That means that if by any chance they don't receive your medicals, you can actually file the next time when the RFE comes in. You should be able to do that. That's one thing we recommend because of the manual maintenance of the file. When you send a file to one particular address, we don't know if it's going to the officer or not. We want to make it very easy for the officer so that when the things come in, it's going to be easier for the officer to adjudicate the applications though. Now the controversial topic, Rebecca. I have filed adjustment of status in downgrading from EB2 to EB3. I am working with Coca-Cola when I filed my 485 application. My priority date is February of 2014. Now I moved to Pepsi. Now my priority date is not current for final action date in EB3, but it's current in EB2. Can I file my 485J supplement with Pepsi using the EB2 I140 approval of Coca-Cola?
It seems like, according to our understanding of interfiling, that shouldn't be possible because an I485J supplement filed by the second employer, Pepsi in this case, shouldn't really be able to, claim the EB2 approval of a prior employer, Coca-Cola in this case. There isn't anything in the interfiling guidance that, on this scenario saying that it is possible, but we do seem to be getting kind of conflicting information or guidance from USCIS in the form of the requests for evidence that they're sending. Our office, as well as other applicants that we've seen who have consulted with us, have shown us RFEs where USCIS is sending an RFE for the I485, sometimes for a medical exam or something like that, and at the bottom of the RFE they're stating that you are eligible to interfile your case, transfer the underlying basis of your case from EB3 to EB2 because you have this EB2 I140 approval notice, and they cite the actual case number of, for example, Coca-Cola's EB2 I140.
Not EB3 Coca-Cola, right, but EB2 Coca-Cola.
Mm-hmm. So USCIS in these RFEs seems to be saying that you can interfile, and we have proceeded with that in a couple of these cases, making the client aware that we are not, there's no clear guidance from USCIS other than these RFEs on this situation saying that, this is doable. I think we're still waiting on the outcome of those cases to see what happens.
We have also filed some of the things even if the RFE was not there using the 485J supplement, but as of now we haven't seen any results. USCIS has not indicated anything. It may be too early for us to judge if we can do EB2 filing from Coca-Cola when you're working with Pepsi though. Now, obviously, I have to tell you that even though you have moved out of Coca-Cola and you're working for Pepsi, Coca-Cola can still do interfiling from EB3 to EB2 even though you're not working for that company. That's for sure. Do the EB2 filing with Pepsi. If Pepsi files a labor certification, Pepsi gets an I-140 under EB2, for sure you can do that. We have no problem for it. Or if you have an I-140 approval with a third company, let's say ABC Consulting Inc. under EB2, you can still do the porting from EB3 to EB2. You can still do it. That's probably you can do that. But we are not sure that if you're working with Pepsi, can you use the EB2 approval of the Coca-Cola and do it? We are not sure about it. We have tested it, and we will give you the report as we go on, though. Rebecca, what's going on the 485 adjudication? Are things moving faster? Are things moving slower? What's going on that?
Yeah, so there is kind of some hopeful news just in the last few weeks. From the end of May, I would say we've been noticing really an increase in the I485 approval rate. We've been kind of tracking it just for the approvals that are coming through in our office, and the ones that we've received so far, I think in June, have already kind of almost outpaced what we received in an entire month in the past. So USCIS does seem to be, like they said, picking up the pace of their I485 adjudications. Like we've mentioned in the past, USCIS's most recent statements to the American Immigration Lawyers Association was that their goal is to adjudicate the eligible I485 applications by September 30th of this year that have been filed before June 2022. So that is a lot of cases. If they are able to do it, that would be a huge accomplishment, and there's still a long way for them to go, even though we've seen kind of the pace pick up in recent weeks. But yeah, they do seem to be kind of on their way to hitting that, potentially, if they keep up this pace and sort of increase the pace. It does sound like the transfer of underlying basis, the move to EB2, is kind of speeding up that process a lot, as well as the move of a lot of the files to the the National Benefit Center.
Yeah, we have seen a little bit lagging in the Nebraska Service Center moving to the National Benefit Center. We have seen a good improvement with regards from Texas Service Center moving to National Benefit Center. What will happen when it goes to the National Benefit Center? The National Benefit Center has officers to adjudicate the 485 application by themselves. They're also moving these adjudicating of the cases from National Benefit Center to the local offices. So for example, if you're in Florida, they can move your file to Florida. Now there are some cases, even if you're in Florida, they move your file to Los Angeles also. They have the authority to issue an RFP, to adjudicate the case, and probably issue a notification for you to attend the interview in Florida, though. That can be done. Those things are able to be done. We are seeing a lot of adjudication done by the National Benefit Center. We are seeing a lot of cases that have been transferred to the local offices that are getting adjudicated. So we see a lot of improvement. If this pace continues, though, there's good possibility that they may come very close to using the 280 or 290,000 green cards that have been allocated to the employment base this year. There's a good possibility that we can achieve that target, though. Let's go to the side issues that come up very frequently that we want to update. We are noticing, because of the lot of new officers adjudicating the green card applications, there are wrong names, wrong green card codes that are there. If you have a wrong green card code on your green card, which is approved, though, you should contact the immigration lawyer. If by any chance your name is wrongly printed out there, let's say for example your name is Rahul, instead of Rahul it says R-A-H, and then they forget U-L. What you could do is you have to file, to correct the name, you have to file something called I-90 form, and you have to send the green card approval that you got it, the green card that you got it. You have to send it back to them. That's where it becomes a problem. If you send it back to them, how would they actually give it back to you? Now, it may take almost like 6 months to 1 year for them to give the green card back. What are you going to do in between? What if you want to travel? You can make an InfoPass appointment. You can go to the local office. They will stamp your green card saying that you actually have been green card approved, and that will allow you to travel outside the country and to come back in. These provisions are there. And what should you do if your name is wrong and if you want to travel immediately, though? If you have Rahul as R-A-H and UL is not there, I tell you, you can travel, absolutely not a problem. They will check you, make sure that you are the right person. They will do the biometrics. If you are the right person, you are real Rahul, then they will allow you. Absolutely, we don't see any problem. Small mistakes, those things will not hinder you in traveling. But for eventually to get the green card corrected though, please follow the procedure of I-90. You can look into the form at USCIS, it's called I-90. A lot of people have this question that if you get a green card, what to do? Because a lot of people are getting the green card right now. We see that the employers are threatening the employees that, hey, you can't leave the job within 6 months after you get the green card. That is not true. As soon as you get the green card, you can definitely move out of the company, no problem with it. Even if they threaten or if they do anything, you can ignore their threat and you can leave the company. You will not have any problem in getting in your green card revocation. You will not have any problem in getting citizenship. We have never seen any problem. One of the other common things that we face, especially coming from the South India though, what happens if you get married with the cousins, first cousins? Are you allowed to come here on H1B or H4 or dependent visas though? Here is one of the issue that pops up though. Technically speaking of, in South India though, if you marry with your first cousins, it's perfectly legal. In most of the United States also, it is perfectly legal if you marry the first cousins. But the consulates are interpreting the law that it is against the public morals and they are denying the entry into United States if people are getting first cousins marriage. And that's very hard to overcome if they deny that. My suggestion is that if you are married to the first cousins, it may be probably worth for you to consult a lawyer. Because when you go for the interview of the 485 though, they don't ask the question whether you're married to the first cousin or not. It's not there in the DS-160 form. They never ask that question. It's only when you volunteer that information, they come to know that you're married to the first cousins though. The common question that they ask is that, how did you get to know your wife? And then you say, she is my first cousin. You're in trouble. That's where the trouble comes. There are other ways to answer that question. This is an arranged marriage. Because it's an arranged marriage, if you just say it's an arranged marriage, they may just keep calm. You don't have to answer the question. Now, if they particularly ask the question that, is this lady your first cousin, then you don't have an option. You may have to answer the question though. But otherwise, I don't want people to volunteer that information to them that they're the first cousin. Now, this is not hiding the information. This is perfectly okay if you say that you got married because of arranged marriage. Let's go to any other questions, Rebecca, before we go to question and answers.
I think we're also just going to mention that we've been getting a lot of questions about interfiling medical exams, whether to do it. So one advantage right now is that even though medical exams used to expire within 60 days of the physician signing the I-693 form, there has been kind of some grace period right now that up until September 30th of this year, you can submit a physician's medical exam even if the doctor signed it more than 60 days ago. So there's that sort of grace period in place right now. So given that, if you did not include your medical exam with your initial I485 filing, we are recommending that with USCIS, picking up the pace of their I485 adjudications, if you want to try to avoid or minimize the chance of an RFE being sent just for your medical exam, you can try interfiling your medical. It doesn't guarantee that the medical exam will get matched up to your actual AOS file because, like we said earlier, they're physical files. Even if it's at the National Benefits Center based on a transfer notice, it may have been moved to a field office somewhere in the country that you don't know where it is. So it may not get matched up to the actual physical file, but if it does, then that will save time. You won't have to go through an RFE. If it isn't, then the worst case scenario is you will get an RFE later. So we're recommending that people can keep a copy of the same medical exam, ask the doctor's office to make a copy for you so that you have one ready, also in a sealed envelope to send in response to an RFE in case the interfile attempt is not successful and you still get an RFE for the medical exam.
A question from Mark is that, does the DOPROX appointment will be extended next year though? Mark, Dropbox has been there for a decade, almost a decade right now. It will be there. The only question that comes up is that we for sure know that if your visa expires, and within the same category, if you're applying for the visa, you will be fine if you're applying within 4 years after, within 4 years after your visa expires. You can do it next year also. But we're not sure if it crosses 4 years, if they will extend that. We are not sure if you're moving from F1 to H1, they're going to move. We are not sure about that. Hopefully so, because of all the caseload that they have, we are expecting them this to be continued for a long period of time. That is our hope, but we'll see. We'll update you on that though.
Ram Kumar is asking for an H4 visa interview at the consulate. Can they go based on an H1B receipt notice that is not yet approved? So that's not possible. For the H4 applicant to apply for the visa, it does need to be based on an H1B approval notice if they are applying at the consulate. So they would need to wait until the H1B is actually approved. That's not the case if they're an H4 applicant filing within the US, submitting the I485 application. In that case, you can file an H4 extension or change of status application based on the H1B receipt notice, but at the consulate, the H1B application does need to be approved.
Sneha Mehta is asking this question. GC holders cannot stay outside USA for more than 6 months in a year without a re-entry permit. Are they saying the calendar year or 1 year? Sneha, you are interpreting it a little bit differently though. Here is one of the rules though. Whenever you are outside the country for more than 6 months on a single stretch, that means that when you go outside the country and you are coming back after 180 days, you definitely are under a risk that there's always a chance they may question you, deny your entry if you're doing that frequently. That is the risk that is there. There's also another risk that poses if you're outside the country for more than 180 days. Especially for the citizenship, it may pose a risk. What we normally tell is that if you are going outside the country for more than 6 months, on one single stretch though, you definitely consult a lawyer though. For example, if in a span of 12 months, you stay 3 months in United States, 4 months in India, and 2 months in United States, and the rest of the period in India. So overall, if your presence is 7 months outside the country, technically that's not a problem though, because you're not going outside the country for more than 180 days on a single stretch. You're going on installment basis. When you go on installment basis, you're not going to pose a risk for your green card though. You also need to consider that out of the past 5 years, you have to maintain the physical residence of physically present in the United States for 2.5 years. You need to count that. But as such, if you go 4 months, come here for stay for 2 months, and then go for 4 months, we do not expect any problem for you.
There's a question from YouTube asking about kind of the reverse issue that we were discussing earlier. They interfiled to EB2 first with their, it sounds like, existing I140 petitioner and are now asking can they move to a different company in less than 180 days from the time that J supplement has been filed. So USCIS has actually addressed this in their guidance on their website, unlike the other situation we were talking about at the beginning. USCIS has said that in that case, when you're transferring the underlying basis from one EB category to another EB category, the transfer restarts the 180-day AC21 clock that would allow you to safely change employers. So that is on their USCIS website and their guidance on transfer of underlying basis. Whether that is actually true, whether you do need to wait 180 days again from the time the J supplement was filed, I mean, of course, it's been well over 180 days since you filed your initial I485. According to the AC21 regulations, it seems like that is all that is needed, 180 days from the initial I485 filing. There's nothing that says that you need to, in the regulation, that says that you need to restart the clock. That's on USCIS's website. So we have had people try that, move employers in less than 180 days since interfiling to EB2. And we're still kind of waiting on the results to see if those I485s are going to be approved. If you do decide to, I would say the worst case scenario is that if USCIS doesn't allow you to, they would just keep your I-485 pending in EB3. It doesn't seem like there's any reason they would flat out deny the I-485 application. It would just remain pending in EB3.
Bharat Rawalapati wrote letters to the senator. My case is stuck in NBC for 8 weeks. Anything I can do to make them notice it? FOIA request, etc. Bharat, no, we do not recommend that you file a FOIA though. We have been noticing that when you file a FOIA, they're actually pulling the file out of the line. That's a recent things that we learned. We thought that when you file a FOIA, they'll just go online and copy it and send an email to you. That's what we thought, but they're actually pulling the file. That was very shocking for us. So we do not recommend to file a FOIA for you to get the attention though. There's nothing you can do. Things are going much fast, but there's nothing you can do right now to expedite your case though. Wrote letters. There are a lot of people who have written letters. If you have written letters, please let us know. There is a new letter that we kept it in this link though, which we did not provide in the previous one. There is an update that has been done. What updates have been done in this particular letter where we do not want to waste the green cards? Of course, we do not want to. Remember, because you have been writing the letters, because you have been following with your senators, you're being contacting the congressman, you're contacting the USCIS, you're contacting the ombudsman. USCIS has definitely paid attention to the business immigration. They said they are going to process fast. They have moved it to the National Benefit Center. They have revolutionized the things. Some things we may like it, some things we may not like it, but I would say one thing, from the beginning of this fiscal year to right now, things have improved a lot more. But what we were shocked to listen to is that the USCIS has the authority to assign the visa number, that means the green card number, to you before they approve the case. I mean, when they have an I-140 approval, they can assign the case and they can give you the green card at a later date. How do we come to know? I mean, recently we got an EB3 485 approval. And then final action date is not current. The person never had an EB2 approval in their life, the only EB3 approval. And now what we were scared for this particular employee who got the green card when the final action date was not current is that maybe they will revoke my client's green card once they at a later date. Maybe at a later date when they go for citizenship, that will create a problem for our client. That's what we thought. So we contacted the Ombudsman's office, and USCIS responded to that when the final action dates were current for our client though, they assigned the green card number from them. They didn't adjudicate that application for us at that point in time. They are adjudicating this case right now when the final action date is not current. We didn't know that. So, I mean, please excuse me. I mean, I've been a lawyer, immigration lawyer for 25 years. There are a lot of things we come to know. It's because of your education. It's because of the USCIS educators, of course, my own colleagues, my junior lawyers, my senior lawyers, my ALA, all these things educate. It's all we need to come. We came to know that, wow, they can assign the things. If they can assign the things, why did these damn guys wasted the 60,000, 70,000 green cards last year? Why can't they assign all the green cards right now to the people whose 485 has been filed? And if they deny the 485 application, they can take it back. Why can't they do it? So this particular letter, what we are telling is that, hey, assign the green cards to these people. When they get the rejection, if by any chance they get the rejection, you can undo it at a later year. We've been telling that previously though, but we didn't know that they can do it. They are doing it. So this letter tells that please assign that. Now, there's also another request. If they can assign it, why can't they assign it when we file the 485 application? Why are they assigning it at a time when they're getting the green card? So, for example, in the H1B, when do they assign the 65,000 green cards? When we file with the $10 thing online, when we go, okay, John Doe is filing with ABC Inc. We pay $10. Boom! If it's picked in the lottery, what do? They assign the number. they can do the same thing for us. In that way, we don't have to waste the green cards that are available right now. So this particular letter that we have put in right now, it's put in on my business partner, immigration girl, which is Reddy Neumann. Please, this letter is very good. We want, if you have written the letters previously, write it again, because there are different points there that need to be addressed. Please keep writing letters. Thank you.
Ben Cat from YouTube is asking about his wife's I485 application, which is still pending, even though his green card was approved last month.
Excuse me.
Let's see. Congratulations, Ben Cat, on your green card. This is a pretty common, or at least it's not uncommon, your situation where, as I mentioned earlier, families who are filing all together sometimes are not having their I485s approved all at the same time for some reason. And it does seem to be a situation of just the physical files for some reason were handed to different officers who are working at different paces. In those cases that we've observed, which has been happening since last year, the entire families does always eventually get approved, even unless there is something unusual in that one pending case, like a criminal matter or something like that. But if there isn't anything like that, the rest of the families does eventually get approved. It can take a number of months, I would say 6 to 8 months, potentially, hopefully not that long, but a couple that I've had in that situation, it took about 6 to 8 months sometimes on the longer end for the remaining family members to get their I485s eventually approved. It just does seem to be kind of a matter of time. But you also kind of mentioned, are you able to travel on the green card? What's your wife's status during this time? So even if you don't travel, even if you're here in the US, your status has changed to that of a green card holder. So if you were previously in H-1B status, you are no longer an H-1B visa holder, which means your wife, if she had an H-4, her H-4 status is no longer valid once you became a lawful permanent resident. So that is something to keep in mind if she was using an H-4 EAD. If she needs to travel, she can only do so using an advance parole that has been issued based on the pending I-485. She won't be able to travel using an H-4 visa or anything else related to the H-4 anymore. But otherwise, she is authorized to remain in the US while the I-485 application is pending, and can travel and work using an EAD AP, which hopefully have been issued at this point.
Senthil has this question: can I do a second job while 485 is pending for more than 180 days and have not received the EAD? Yes, Senthil, if you have the second company file a concurrently filed H1B, because since you don't have an EAD, you can do multiple jobs on 485, and I'm assuming that you're going to file the concurrent H1B. Question from Abhijit: how long is it taking for the I140 premium processing upgrade notice? It's taking about 1 week to 10 days nowadays for the premium processing receipt notice. The good news for the people who have downgraded from EB3 to EB2, EB2 to EB3 is that, guys, the premium processing, all premium processing are getting accepted. So if your lawyer is telling that, nah, it got rejected before, my other case got rejected, go contact them again. Every premium processing case is getting accepted, is getting adjudicated. So tell your lawyer that they should convert into premium processing. A lot of people ask this question though. I filed the interfiling into EB2. My previous I-140 and EB3 is not approved. Is that okay? I mean, this is our personal opinion. We don't have a confirmed thing from the USCIS. We think so that your underlying I-140 for EB3 also should be approved. I don't want to give the officer any reason to hold your case. They told us they are going to adjudicate the cases that were being filed by June 2022 by September of 2022. I mean, that's an unofficial information that they give it. Does it mean that I'm going to just sleep around that? No, I won't do that. I want to get my case in the officer's hand. I don't want any excuse to be given by the officer. Oops, The underlying EB3 is not approved, so I'm not going to issue. The medical is not there, I'm not going to issue. So try not to give any excuses to them. I am telling you that if I were you, it's worth spending that $2,500 and get the damn EB3 I140 approved out of your way. Neeraj has this question: does automatic revalidation clear issues in the gap of employment and will not be issued in stamping? Neeraj, there is a different issue when it comes to the stamping, and there's a different issue when it comes to the 485 green card though. Definitely if you have a gap of employment though, I would definitely request that you contact a lawyer privately though, because that's something that you need to discuss privately though. Sandeep has this question: I did receive the 485J receipt notice. Does it mean that interfile request is accepted? Well, there's a difference in acceptance and approval though. They definitely received it. Does it mean that they approved your EB2, saying that now you're under EB2, not under EB3? We don't know that yet. At least they have acknowledged the receipt notice. That's very good news. We do see that initially when we got the 485J supplement for the interfiling, we didn't get, we started filing in last week of January of 2022. Until about March, April, we were not getting anything from them. From starting in April or so, we started getting the receipt notices. However, though, in the last 2 weeks of May, we started getting the approvals for the cases that we filed in interfiling. And in June also, in the past 15 days, we've been getting approvals for the interfiling. We are also getting for the cases that we have refiled applications. So things are going very good with the refile, interfile. Although the refiled applications are more getting approved, but I think so that interfile is also catching up though. All I tell people is that if you have not refiled the application though, and if you are eligible for interfiling to EB2 though, do not hesitate, interfile. That's what I would do if I were you. Now, if you're thinking that, okay, EB3 is going to move forward, that's up to you. I mean, I'm a very wrong guesser. Believe me, I've guessed so many times wrong predicting the priority date. There is nobody else in this world that have predicted so wrong in priority date. I can challenge it. I have evidence. I'm the worst guy in that thing. So if you think so EB3 is going to go forward, you don't have to interfile. If you think so that EB2 is going to stay there, do interfile ASAP.
Sanjeev from YouTube is asking, to transfer from EB3 to EB2, does it require redoing the PERM and I140? So when we talk about interfiling from EB3 to EB2, we're assuming that you already have an EB2 approval notice, usually with the same I140 petitioner that your EB3 was filed with. In that situation, it's very easy. You don't need to redo a PERM or I140. The I140 petitioner just submits the I485J supplement confirming that the EB2 job offer is still there and exists, and you request that you transfer the underlying basis of your I485 from the EB3 that it was initially filed with to the EB2 I140 that you also already have. If you do not have an EB2 approval already with your current employer or the I140 petitioner, it would require doing the PERM labor certification and the I140 again, which with current processing times, it's the PERM that really takes the longest amount of time from beginning to end. At minimum right now, it would be a year, most likely due to the DOL processing times.
Priyanka asked this question. Priority date is November 2013. She moved to a different company. PERM is just approved. Should I file I-140 and 485 together, or should I file a separate 485? Straight answer from my very straight opinion. File I-140 in premium processing. Wait until the premium processing is approved, then file the 485. Your priority dates are current until July of 2022. So you have the option of filing it right now. Now, if by any chance, if there is an RFE, and if your I-140 is still not approved by July, you can file a 485 with a I-140 receipt notice. And if by some miracle circumstances, though, you won't receive the I-140 receipt notice by end of July, and the priority dates are going back in August, though. Now, this is just for Priyanka, guys. Don't tell that I'm telling that prior dates are, if they, by any chance in August prior dates are going back though, then what I would do is that file an I-140 and 485, because that's a life and death situation at that point of time. Because you miss it, you may miss it forever. So under the current circumstances, file I-140 in premium processing. The reason I tell is that if you file I-140 and 485, guess where your application is going to go? It's going to go to Nebraska, or at best it may go to Texas. Either way, that's the bad thing. It will not go to National Benefit Center. Then your I-140, our guys are going to adjudicate it, since it's a premium processing. They may adjudicate it. Then they have to transfer it. Then you're at the bottom of the line. Remember, they are trying to transfer all 485 cases to the National Benefit Center. You're at the bottom of the line, you're not on the top of the line. But if you file an I-140, get an I-140 approved, go to the 485, you're straight up going to National Benefit Center though. A question from Anup Patel though. Is it a good idea to file, interfile? He filed 485 in EB2 straight in January though. I don't think so. It's a good idea. Anup. Here is the reason. We do publish the data, but I want you to watch the data next week, because immigration girl Reddy Neumann is in the ELA conference. She's speaking. She's one of the speakers there in the ELA conference in New York. We're going to update it. Now, we have seen the cases somewhere filed in November and December, straight filing applications. In November or December of 2021 are getting approved. You're in January though. Although we have some cases that we filed in February and March of 2022 that got approved. In your case, I would not interfile though, because who knows, how they are going to treat the interfile. The officer looks into it, he may get confused. Right now, your case is not in a mess. Your case is in NBC. Anup, I will not do anything if I were your lawyer.
Debbie from YouTube is asking about his travel to Canada. His H-1B extension is approved. His wife's H-4 is still pending. And can they go to Canada and get the visa stamping and come back? If you're able to secure a visa appointment at a consulate in Canada, you definitely can. It sounds like right now the main challenge is getting a visa appointment at one of the consulates in Canada. For a long time, over the past 2 years, I know that Canada wasn't accepting any what they call third country national visa applications, which means they weren't accepting visa appointments unless you were a Canadian national or a Canadian permanent resident. I believe that they have lifted that restriction and are technically accepting third country national applicants, but visa appointments are still quite difficult to secure in consulates in Canada. So that may be kind of the main challenge to that. If you are able to get an appointment, you definitely can do that. That would probably, it could be a faster way of getting the H-4 extended. Another option is trying the kind of automatic revalidation if your wife's H-4 I-94 has not yet expired. We've discussed in the past traveling to Canada or Mexico in order to try to get an extended H-4 I-94 from CBP if you re-enter together. In the majority of cases that we're hearing is that they're giving the I-94 end date for both the H-1B and H-4 as the H-1B extended end date. So that could also be a faster way to extend the H-4 without waiting for the I-539 to be processed. One thing to keep in mind is if you are going to Canada, you of course need a Canadian visitor's visa. If you're trying this in Mexico, it seems like we've been hearing more cases of Mexican immigration requiring you to have a Mexican visitor visa in order to travel to Mexico if your US visa stamp is expired. Even if your I-94s are not expired, we've been hearing that Mexican immigration is more and more asking for the Mexican visitor visa, or they're still admitting people but telling them, like, next time you come, make sure you get a visitor visa. So that may be something to keep in mind if you're going to try the same thing but traveling to Mexico instead of Canada.
Some questions for Jennifer. The I-140 is approved. Can I file a 485? My prior date is not current. The answer is no. You cannot file the 485 if your prior date is not current. Can I do 2 jobs on a H-1B? There are 2 things here though. Is it 2 end clients? If you have 2 end clients here, you don't need any amendment. You need to speak with your immigration lawyer. But if you want to work for 2 different companies though, then you need to have the second company file a concurrently filed H-1B, Jennifer, to start working for the second company though.
Rakesh from YouTube is asking about the impact on the green card processing if he were to get a promotion after his perm is approved, but before his I-140 and I-485 are filed. So one thing you need to be, for the I-140, the position that you identify on the I-140 does need to match the position that is in the approved perm application. So it doesn't necessarily need to match your actual current job, but it does need to match the offered position that was described by the petitioner in the perm labor certification. So if the company is still has the perm position open and is willing to file the I-140 petition offering you that future position, that is fine, even if your actual current job is slightly different. Even if it's, you know, not that different, it's, you know, it's most likely still fine. So I would lean towards, you know, having the company just file the I-140, offering you the perm position rather than refiling the perm at this point, because that, as I mentioned before, would take most likely another year. And I believe Rakesh mentioned that his priority date is current. If the company is not willing to do that, then it may be a matter of even just not taking the promotion at this time, staying in the current job if that's the only way they're willing to file the I-140. If your priority date is current right now, I would do that.
Sud is asking the question from YouTube, is there any way I can help to move my case from Nebraska to NBC? I don't know of any way that we can request them. A lot of people are asking me to predict the priority date, guys. Let's do one thing. We hope all of you guys write letters, because here's the one thing: if your priority date is not current, you have not filed the 485, you want all the people who are ahead of you kicked out of the line. They get the green card faster, you have a better chance. So to kick them out of the line, the best thing is that they need to get the green card. So you keep writing the letters that we're writing at the bottom. Said you've been waiting for this green card. You want to these buggers who are in front of you need to get the green card before they give a chance to you. So the best way is, instead of asking me the priority date and making me predict the wrong priority date, you write the letters to the congressman. We're giving the draft of those things. Not many people do that. Only people speak about it. You go to the other things, they don't. We are giving those things for you. It's been working, guys. I mean, these letters are working. So instead of telling me when the priority date is, keep writing letters. Take the charge in your hand. Don't give it to me. Don't give it to Rebecca. I already got my citizenship. Believe me, I did. Rebecca is born here. She doesn't need an immigration lawyer ever. She never needed it. She is one, but she never needed it. I needed it. You want to get rid of us, you keep writing those letters. You'll get rid of us as soon as possible.
VM from YouTube is asking about the trend that we're noticing for I485 interviews or interview waivers. So we are still seeing that the majority of I485 approvals are being approved without the in-person interview being required. It still does seem like the in-person interview is only being required if there is like a criminal issue, serious immigration violations, or in some cases, we're noticing that all employment-based applications, if they're with a company that has been kind of under investigation by USCIS in the past, or there was kind of a complicated issue with the I-140s, maybe a successor in interest situation with the I-140s, if there was a merger or acquisition of the I-140 petitioner, sometimes all the beneficiaries of that company that filed their I-485 based on that company's I-140 are getting called in for an interview. But for the most part, those situations are kind of going through pretty easily as long as everything checks out with the company. But the vast majority of straightforward I-485 applications are being approved without an interview.
Question with comes is that Manohar Goodiwada is asking a question from Facebook. My company has been acquired by another company in January of 2022. Can I file I-140 EB2 amendment in premium processing? I would not do that. Since your labor certification has expired for more than 6 months ago, you're filing an amendment, I strongly recommend that you file in regular processing. I would want you to convert into premium processing as soon as you get a receipt notice, though. I don't know if they would route now, accept it. Previously, they were not accepting premium processing for some of the amendments, and when labor certification has expired, and especially when the downgrade, we got a lot of premium processing rejections, but later on they got accepted. But now, Manohar, they are accepting every premium processing case that we are doing. But I still suggest you do not file in premium processing, file in normal processing, convert into premium processing at a later date. Poonam is asking the question, oh, I was stupid enough to file an I-140 under the regular processing. Now, should I tell my employer to file one more I-140 in premium processing? No, I mean, you can convert the existing I-140 in premium processing. You don't have to refile the entire application again.
Surrender from Facebook is asking about the filing location for his H-1B petition. Can he choose the location, or him and his attorney, can they choose the location, or is it based on something mandatory? So unfortunately, you cannot choose the filing location for your H-1B or really any employment-based immigration application. You can't really choose the service center it gets sent to. For H-1B purposes, your filing location is going to be based on the state where your H-1B employer is located. So the address that they have identified as their company location on page 1 of the I-129 form, that state is going to determine the service center that the petition should be filed at, if it's an H-1B extension. And they'll need to check the USCIS website for the service center. There are 4 different service centers. If you send it to the wrong one, they won't accept it. It will either get sent back to you in the mail or to your attorney in the mail, which can take several weeks. In a few instances, for some reason, USCIS actually sent it to the correct service center, but I wouldn't count on that happening, so make sure it gets sent to the right service center. If you have a cap subject H-1B application that you're filing this month, make sure it gets there by June 30th, and make sure you are filing it at the location that is listed on your selection notice. So for cap subject H-1Bs, it's not based on where your petitioner is located. You have to file at the location listed on your registration selection notice.
Rebecca, I want you to be involved in this. Akash Reddy from YouTube is asking a question. Can I do 2 jobs from 2 different end clients with my employer? Did I hear it right? Yes, you heard it right. You can work for multiple clients for the same employer. You may not need any amendment. You may not need any concurrent filing H-1B. You definitely don't need to file a concurrent H-1B. You most probably may not need an amendment. You might have to check with your employer. I don't know why people are surprised. How many clients you work for our office?
Yeah.
How many? 50, 60, 100?
Yeah, probably.
Yeah. She works for 100 clients from Reddy Neumann PC. If she was on H-1B also, that's part of her job. Even though we may have said that she works, but there's nothing wrong. She works for 100 clients, more than that actually. So yeah, you're one of our clients if you pay us the money, and then she'll work for you. That's nothing wrong. Yeah, you can. Akash, you heard it right. You can work for multiple clients for the same employer. Your H-1B most probably already covers. If you're working in the same location, for example, you're working from home, and then you're working for multiple clients, nothing wrong with it. If Rebecca would have been on H-1B and she's working for 50 clients, not violating H-1B if she was on H-1B. I don't know why people, it's very surprising sometimes. The interaction with you guys also gives us knowledge. Oops, we didn't know that. You guys didn't know that.
Yeah, I guess in the past, the amendment requirement was always for a work location change, which is still true. If you're moving to a different MSA physically where you're doing your work, that does still require an amendment. And I guess pre-pandemic, working for multiple end clients may have meant working in different physical end client offices because that's the way it was at that time. But with the situation now, if you're working entirely remotely and you can do all your work for multiple end clients, all from your one home that's listed on the LCA, then that doesn't require an amendment.
Yeah, very surprised. Our popular video is concurrent working for multiple employers on a H-1B, but maybe we need to we need to revise that particular video and then probably put more questions working for 2 different clients or 3 different clients with the same employer. Yeah, okay, you heard it very right. Anything else?
No.
If you have any questions, guys, please try to make an appointment. You don't have to make an appointment with me and Emily or Rebecca. There are other very talented immigration lawyers in our office, especially Stephen Brown, Justin. We do have Ryan, we have Crystal, we have Ruth. We have 16 lawyers. I mean, you need to pick the lawyers. If you're not getting an appointment with me, Emily, I mean, you can always book another lawyer. If they have any questions, they'll always come to us to ask the questions. So please, if you have any consultations, try to book. Thank you very much for tuning in. Thank you, Rebecca, for coming.